Amid the controversy where Arvind Kejriwal has sought recusal of Justice Savarnakanta Sharma, the questions around the fairness of judiciary are back in focus. But, however, we are not talking about the controversy here. We're going to talk about the legal term that is in focus, which is recusal application. So, to give our answer on this all doubts, today we have Advocate Nitesh Mehra with us. So, thank you so much for your time.
Thank you for calling me.
So, first of all, I know that you will not answer the questions around the case, but the legal term which is in focus right now is the recusal applications. So, the students which are, listening to you right now and the advocates also, can you just answer as a basic, what is this legal term we are talking about?
So, if you talk about this term recusal, so this recusal is not codified anywhere in any statute in Indian context. And as a literal meaning of recusal is stepping down of a judge from a particular case on the ground of bias. So that is the literal meaning of recusal. And we further term it in two ways. One is that the conflict of interest, another is the apprehension of the bias. So this is the literal meaning and definition of recusal according to me.
So we are hearing that there is a question of bias. So with just the mention of bias, can we sort an application of recusal?
See, recusal is of two types. So fundamentally, the recusal in our Indian context of judiciary is where the judge themselves step down from a case where they feel that they could not give a impartial and fair justice to that litigant and they recuse from that particular case. However, the second one, where the parties bring it to the concerned judge, has to be seen very carefully. There are reasons behind it because we have seen in the past that the litigants, in order to have the bench hunting, go for the recusal applications, and further the recusal applications, if allowed generally, would open the floodgates. So therefore this recusal application is generally not brought by the litigants, but yes, recusal fundamentally is founded on the principle where the judge on its conscience recuse from that particular case.
So I will like to have your point of view on the case, how you see the case.
See, as far as this particular case is concerned, I would not be able to give any comment on that since the matter is sub judice before the Honorable Court and the orders are yet to come. So we all would be keen and interested to see that how this particular application will be dealt by the Honorable Judge.
For the young advocates and the law students, so what exactly the process of filing this recusal application?
So generally, if you talk to me with regard to the recusal applications, in my career of law, I haven't moved even a single application of recusal before any court of law. Since if every law student is watching this and the young professional advocates are also watching this, so I would say that generally we should not even indulge in the cases where these recusal applications are being moved, because sometimes they are motivated and these can be seen as in the interference of justice. So these applications undermine and lowers the reputation of the court also when it has been brought to the particular judge. However, what we see is that our courts in India are following Article 14 and 21 of the Constitution of India for dispensing of fair and impartial justice, and they do not themselves deal with the cases where they even get a hint or a pinch that this matter would have somewhere have a position and it may get related to them, so they simply recuse it without giving any reasons. So my last advice to the law students is that they should fight their case on the merits rather than going for the recusal application.
So that is the gist of recusal application for today. And thank you again, sir, for joining us.
Thank you.
And for more legal explainer like this, keep watching Verdicto.
Thank you.